So, Stephanie, one of the things that I learned early on in the practice of law as a civilian military defense lawyer is that the National Guard and the rest of the Army and the other services are totally different entities. When I was hired in 2017 on my first Guard case, it was a board. And I just thought I'd go in and defend the soldier in a board until I started. And the SJ is like, so you licensed in Arizona, Will? And I'm like, no, I'm not. And so I had to go through this whole pro hoc vice licensing to get temporarily licensed in that state because it was a state action, not a federal action.
Yep. So I think a lot of the issues that come up with each National Guard state, some states have their own state code of military justice. Some states don't have that. Some states still use the UCMJ absent their state code. Some states have a state code, but they don't require licensure in order for you to represent a soldier in a board or something like that. The states that I've been a judge advocate in, a lot of the board actions are really based off of Army regulations. And so once you are certified as a judge advocate in the Judge Advocate General's Corps, you're qualified to represent soldiers in boards. And so you really need to pay close attention to the documents that are given to the soldier and the basis for whatever it is they are receiving.
I guess the bottom line about the National Guard is each National Guard is different.
Correct. Yep.
And they make their own rules.
Correct. It's the beauty of state sovereignty, right? So while the National Guard is a reserve component of the United States Army, rather than answering to the President of the United States as the Commander-in-Chief, they answer to their state's governor. So the governor is always the one who will appoint the Adjutant General, and then the Adjutant General gets to choose his or her staff. And so ultimately you have to appeal to the state government and the state legislature and whatever code of military justice they've enacted.
So here at the law office of Will M. Helixon, we have JAGs, former JAGs who are on active duty. We have former JAGs that were in the reserves, both as their career and then at the end of their career. And we now have JAGs who are in the National Guard. So what would you say the biggest difference between the Guard and the rest of the military services?
So I think the biggest difference that I've found with the National Guard is that there are so many different bodies of law that a National Guardsman can be subject to. And in order to properly advocate for that National Guardsman, you need to know all of them. So usually my first question is, what status were you on when this happened? What status are you on now? Because that will determine what applies to them.
Well, what we've dealt with a lot here at the firm is we'll get a reservist or a guardsman, mostly reservist, that will come to us and say, hey, I'm under investigation for an EO complaint or for a sexual harassment. And we'll go, oh, we deal with that all the time, not a problem. And then they say, but I'm a technician. What does that mean?
So as a technician, you're considered a dual status federal technician. So federal employment laws apply to you. And within the military, especially with EO complaints, you have the military EO program. So you have MEO complaints that can be filed. If you are a technician, somebody can file an EEO complaint against you. And those have different avenues for redress through the agency or through the complainant. And there's different remedies that come with that. So that brings a whole nother area of the law that, to be frank, the JAG Corps doesn't train you in because you're trained in military law. So when you're in the National Guard, you have to know how to handle these extra cases when you have someone who's either, say they're a traditional guardsman and they work full-time as a Title V civilian, or they're a traditional guardsman and they serve full-time as a dual status federal technician. I need to know, or the firm would need to know what status you were on when this happened so that we can figure out how the agency is going to respond. That's another difference, I think, in the National Guard. When you're dealing with federal employment law, you now become the agency. It's not so much the Army is going to do this, the Air Force is going to do this. Every National Guard, most have an Army and Air National Guard. And so it's, the Adjutant General commands over both. So when you have a National Guard technician case, it could be either Army or Air, and just kind of figure out what status they were on, what work day it was. Was it a drill weekend? Was it AT? Were you deployed? Or was this a regular work day when you were serving as a dual status technician? And knowing that body of law that comes with it, and all the adverse actions that can come with being a technician.
We were talking not too long ago about how there's kind of a shift in the National Guard that if an employer, the Guard's like, hey, we don't want this person working for us anymore, it's really a pain in the fourth point of contact to fire them in their technician capacity. So they try to lump everything into the military capacity, because once they lose their military status, they lose their technician status.
Correct. Usually if you are separated from the military, you are allowed to keep your technician job for 30 days. And then after that 30 days, you no longer have a full-time job. And so that is a concern for a lot of soldiers, because if something that they're fighting on the military side could affect their ability to pay their bills, right? So, and sometimes I think a lot of the agencies forget is that there needs to be a nexus to the military service. And I think that's super important to remember when you're advocating for clients, is that whatever action this soldier or this technician is facing, if the agency or the organization intends on attempting to separate the soldier and removing the uniform so that they can remove the technician, there needs to be a nexus to their military service.
And I guess that's always the key, right? If there's no nexus, then it's kind of a fraud to try to separate them from the military just
Correct.
Because it's easier. What law applies if they try to remove a technician in their technician status?
So when someone is facing adverse action as a technician, the National Guard Bureau has a manual that the agency would go by in terms of the adverse action that can be given for each charge, right? Separate from that, there's different appeal options, and it depends on what the agency comes forward with. Certain levels of adverse action have different appeal rights than, say, lower levels do. And you have the opportunity as a soldier, as a technician, to appeal to the MSPB and have your case heard before an administrative law judge, which are things you don't normally have if you are facing, say, some kind of letter of reprimand on the Army side or on the Air Force side.
And much like the reserves, I understand that in the Guard, the timelines are different than they would be, say, on active duty.
Correct.
And those are governed by Guard regulations.
Yep, they're governed by Army regulations. A lot of actually the active duty regulations will have a subsection that most people don't read. If you're National Guard or Reserves, the 10-day suspense time will now be a 30-day. And the reason they do 30 days is because most National Guardsmen or reservists drill every 30 days, once a month. So those are important to pay attention to as well. And I think on both sides, as a judge advocate, either for the organization or as civilian or military defense counsel, there is usually, or there should be, a lot of leniency when you're dealing with a soldier facing adverse action in the military or as a technician who also works a civilian job. I always gave leniency, I know, when I was an agency representative, knowing that these people, this isn't their only job, and they have, families they have to take care of and civilian jobs that they have to answer to outside of their military service.
One of the things that I've noticed about the National Guard, and this is just from me dealing with mobilized guardsmen in their capacity on Title X status, is their culture is completely different than the rest of the military service. I had a case once where the first sergeant was dealing with an E5, right, in their capacity in the Guard. In their civilian job, they worked at the same place, and that E5 was 2 layers above that first sergeant in the management scale.
Mm-hmm. Yeah, so I think that's something that comes into play a lot in the National Guard. One of my assignments in Rhode Island was I was the brigade judge advocate for the 43rd Military Police Brigade. And in that assignment, what I would find a lot of is the traditional guardsmen who are military police on their guard days are also civilian police officers during the week. So where they would serve as peers during the week with people, there would be a rank disparity on guardsman days. And so that is a cultural shift that a lot of active duty don't understand. And it takes some getting used to, and just some understanding that these people, majority of the time that they spend together, say you have an E4 and an E9, a majority of the time that they spend together at work, they're serving as peers. Whereas that can, change when they're on their guard days or in their deployed setting. And that just takes some adjusting to, and, soldiers are human beings, and the relationships are made outside of their military service that can sometimes affect what goes on in their military service.
And that's why it's important when somebody in the National Guard is hiring a civilian lawyer that they find a firm that understands the Guard culture, because that will really craft how you respond to whatever adverse action you're facing.
Correct. And I think what else is really important is understanding that each state is different. I have had the opportunity to work with a lot of different states through my travels as a deputy staff judge advocate, attending regional trainings were not a part of my region, as well as national and all-state trainings. I've got to meet a lot of judge advocates from other states and talk to them and see how their state handles things. And the culture is different everywhere you go. So I think a huge part of being an attorney for a National Guardsman is getting to know the culture of their state and how they do things and how that differs from, the state next door or what else I might have done in the past.
Well, that makes a lot of sense. And that's what we can do for you here at the Law Office of Will M. Helixon. We are your warrior advocates. You defend the nation. We defend you.